Good afternoon, everyone. Welcome to the ninth and the final webinar in our Personal Injury and Clinical Negligence Autumn Webinar Toolkit series. This session is entitled Limitation Toolkit, a Practical Guide to Avoiding Common Pitfalls. Based on the time of year, we could equally have gone for the subtitle, Limitation, the Nightmare Before Christmas. And I say that because when we invite suggestions for talks that we could hold, limitation often crops up as a subject. Now, I assume that's not because people simply go bananas for the Limitation Act. I assume that it's because most people, when they have a limitation problem in one of their cases, it is a nightmare for them, or at the very least, it's a bad headache. And there's a number of good reasons why that would be. Firstly, obviously in limitation, you have an inbuilt looming cliff edge deadline. Secondly, the Limitation Act itself, which is the source of much, but obviously not all, limitation law, is an unwieldy piece of legislation which has exception built upon exception, which can become very confusing. Thirdly, the courts are very unforgiving of errors. Ignorance of limitation is no defense, as we will see later on. And finally, and perhaps most importantly, if you get it wrong, the consequences are about as bad as it can get in litigation, which is that your client may lose an otherwise viable claim, and you may have a claim for professional negligence brought against you. So the purpose of this talk today is to highlight some of the areas where the common problems lie, on the basis that you are much less likely to fall into a limitation trap if you know that it's there. We're aiming for breadth to cover most of the major considerations in limitation periods for personal injury and clinical negligence claims. Each one of these subtopics would merit a talk in its own right, and we do welcome suggestions if there are any discrete areas that you would like us to cover in more detail on a subsequent occasion. I should note at this point as well that at the end of today's webinar, there will be a feedback form which comes up automatically on the screen. We do encourage you to fill those out. They're very helpful to us in planning future talks. And indeed, as I say, if you have suggestions for specific areas you'd like us to cover again, then we will happily do so. So the key questions that you will usually have when limitation comes up as an issue in a case is, one, when did the limitation period, or when will the limitation period begin? And how long is the limitation period? And there are a number of factors which are relevant to that. Rhodri is going to be dealing with the first of the two factors set out in the list, which are what is the status of the injured party, and was the injury latent, i.e. is the date of knowledge later than the date of injury when the cause of action accrued. I'll then go on to deal with where the injury took place, and also situations where common law negligence is not the basis for the claim, because often in those situations the limitation period is not the usual 3-year period. This isn't an exhaustive list of factors. There are other considerations as well. For example, section 32 deals with fraud and concealment, but it's not as common an allegation in personal injury litigation, so we're not covering those aspects. But perhaps one of the reasons why limitation can be quite treacherous in a personal injury claim is precisely because the majority of cases fall into the following categories. That is, a case where you have an adult claimant who has capacity to litigate, so there are no status issues, where the accident causes immediate identifiable injury, so it's not latent in nature, where it happens within the jurisdiction and on land, and where the action is being brought in negligence. And pretty much most of those situations, you have your straightforward 3-year limitation period. What becomes unsettling is when one or more of those elements is different, and you may then find yourself wondering, is the 3-year limitation period still applicable? So if we just briefly look at the starting point for most personal injury claims, which is section 11 of the Limitation Act, as I said before, that is already an exception to the standard position for tort claims, which is that there is a 6-year limitation period for tort claims. Section 11 stands as an exception to Section 2, the special time limit, which we're all familiar with. And I would highlight a number of points in Section 11 before we go on to look at some of the sections in more detail. One of which is there's sometimes a misconception among people that if you have a claim for personal injury that arises, for example, out of a breach of contract, so say, for example, you have a private patient in a hospital who decides to sue their doctor for breach of contract in a clinical negligence claim, people might assume, well, it's a contract claim, therefore it's a 6-year limitation period. But what Section 11 makes clear is that any claim for negligence, nuisance, or breach of duty, whether or not it's based on a breach of contract, is subject to the 3-year limitation period, not the 6-year limitation period. So that's something to avoid if you do have a case which involves breach of contract. A couple of other points to highlight. We'll be looking later at Section 11.1a and also Section 11.3, the wording, an action to which this section applies shall not be brought after the expiration of the period applicable. We'll also look briefly at what the word brought means for the purposes of the Act. So that's the starting point for personal injury claims. I'll now pass you over to Rhodri, who will take you through the status of the injured party and how that affects the limitation period.
Thank you, Jimmy. Good afternoon, everyone. Yes, so I'm just going to reintroduce myself. I'm Rhodri Jones, and I'll be looking at these sort of fairly discrete points in my section of the talk today. So specifically those under a disability for the purposes of Section 28 of the Limitation Act, and this is further defined in Section 38. I'll also be looking at deceased claimants, although they're not necessarily deceased claimants, but those who have a claim that can potentially continue beyond the grave underneath the auspices of the Fatal Accidents Act, or alternatively under the Law Reforms Miscellaneous Provisions Act. I'll also be looking at areas of latency under Section 14, and also looking at the disapplication of the Limitation Act at the discretion of the court under Section 33. So first, looking at disability, this is pretty fairly self-explanatory. It starts, there's an extension period for those under a disability under Section 28(1). It says 6 years there for under disability, but that's altered in Section 28(6), which applies to 11, that being personal injury, or 12(2), that's the limits under the Fatal Accidents Act. And for those two purposes, and for the purposes of the talk today relating to personal injury, it's 3 years. So in terms of those who are under a disability, this is set out in Section 38. This is the interpretive section on Section 28, and it's pretty straightforward. It's either someone who's under the age of 18, that then being described as an infant, or someone who's unsound of mind as defined by the Mental Capacity Act. For those that are under 18, it's fairly straightforward. If there's a cause of action that occurred before then it starts to run at their 18th birthday, and issues should be preceded by their 21st birthday party, if they're so minded. In terms of defining mental capacity, this is the standard definition as is set out in the Mental Capacity Act. It's set out there, and it's essentially affecting impairment or disturbance of the functioning or mind or brain. I mean, it's interesting, I suppose, that people under the age of 18, as defined by the Mental Capacity Act in other areas, may have capacity, but for the purposes of the Limitation Act, they do not. In terms of who has to prove this, it's upon the person who asserts that capacity is lacking, and the standard of proof is the civil standard of the balance of probabilities. In terms of regaining capacity, this is a slightly sort of nuanced situation. This is where somebody who didn't have capacity at the time suddenly regains capacity, and perhaps if you can think of circumstances rather unfairly under some circumstances, once capacity has been regained, it will run from that point onwards. But as it stands, the Limitation Act has got a kind of a safety net in terms of Section 33. So for somebody, for example, who had fluctuating capacity, Section 33 3D can step in, which states the duration of any disability of the plaintiff arising after the date of the accrual of the course of action. So that allows the court's discretion for somebody who perhaps didn't have capacity, regained capacity, and then lost capacity to perhaps still bring a claim later than 3 years from the point of regaining capacity. Certainly, limitation may never start to run for somebody who has received, for example, a nasty head injury, is in a persistent vegetative state. And that was set out in the case there of Headford and Bristol and District Health Authority, where there was effectively a delay of 28 years in initiating proceedings. And although it was deemed to be relevant for the purpose of the cogency of the evidence, the claimant was still effectively allowed to start that claim. There's further complications in this in terms of people who lose capacity. So when the course of action accrues and then the claimant subsequently loses capacity, in these circumstances, the time, again, as with the previous case of regaining capacity, the time continues to run, and again, Section 33 3D of the Limitation Act might step in to be of assistance under that circumstance. Sections 28.2 and 28.3, these are the fairly unusual cases where a claimant who would be under a disability inherited the claim for someone who was not under a disability. And in Section 28.3, there are subsequent claimants who inherit the case from the previous one, each one with a disability. So I'll give the example here of a cause of action accrues, but the person in question, that's person A, is under a disability. Person A dies whilst under that disability. And so the right to bring the claim in respect to the wrong in question passes from A to B, who is also under a disability. So time under those circumstances will run 3 years as normal. In terms of deceased claimants, as they were, so this is claims continuing after death by virtue of the Fatal Accidents Act for the dependents, or by the Law Reforms Miscellaneous Provisions Act on behalf of the estate. So just briefly to recap, the Fatal Accidents Act arises out of a fatal tort, whereas the Law Reforms Miscellaneous Provisions Act is a claim or a potential claim that a deceased could have brought, and this is preserved for the purposes of the estate. Specifically for the Fatal Accidents Act, this is brought by dependents for services, financial dependency, bereavement, etc. And this will run, as it says there, from the time of the person dies, from when they have a viable course of action. Certainly under Section 33.2, the court may disapply this Section 12.1. It's actually a slightly confusing set of circumstances, but as I understand it, the most reasonable way to look at it is to assume that if a person, if more than 3 years from the date of knowledge of the deceased has passed at the time of death, the dependents will be time barred from making a claim. Of course, then the dependents can rely potentially on Section 33 and the discretion of the court to take it from there. At Section 2.2, this obviously is sets out how the Fatal Accidents Act works. So it's a claimant who dies before the limitation of their personal injury claim expires. So at the point, essentially a new limitation of 3 years is born, running either from the date of death or, as it sets out there in Section 12.2, from the date of knowledge of the person whose benefit is brought for. So looking at it another way, time is barred if 3 years have elapsed whilst the claimant is alive and they've essentially failed to bring bring the case, or 3 years after the death or date of knowledge. So that requires a dependent, therefore, to make an action or make a claim within that course of 3 years. And the date of knowledge test, which I'll come on to a bit later, is the same test that's set out in section 14. In the case of multiple dependents, this is set out in section 13. The operation of time limits under section 12 it runs in relation to different dependents. So that essentially means that time runs individually against each dependent. But it's really important in the terms of the Fatal Accidents Act that that all of the potential dependents can be hoovered up in one action. Often they can crop up at later dates, but it's important to appreciate that all the dependents have to be included in this action. And even though under some circumstances the amount of time they will have to run, say for example, if one of the dependents was a child who was under the age of 18, they might have a slightly longer period of time after the date of death. But if you measured it from that point of view and their extended time, then potentially other dependents would be time barred. So the key issue here is to try and identify all the dependents in one go and appreciate that their time's running on them all individually. Looking here at the claims under the Law Reform Miscellaneous Provisions Act, this again is similar provisions to the Fatal Accidents Act, but it's a valid cause of action that runs 3 years from the date of death, or again the date of the personal representative knowledge, whichever is the later. And if there's more than one personal representative and their dates of knowledge are different, it's the earliest one that applies. Essentially, again, it's a new limitation period that opens up after 3 years or from the date of the personal representative's knowledge. And there is a discretion to disapply this under section 33. And that applies to both the primary claim, that's the claim that the deceased could have brought before their death, or the claim brought by the estate under the Law Reforms Miscellaneous Provisions Act. So after all this death and disability, I'm going to look at a slightly lighter and I suppose more nuanced topic, which is that of latent injury. Now, latent injury affects, basically extends the normal period under section 11.4 and includes this area as well, or invokes this discoverability test, which is section 14 of the Limitations Act. So in terms of a latent injury, this is where there's two circumstances where, firstly, either where it's clear that that time can run from when the action accrued, or this later date, this date of knowledge of the person who's been injured. Because it's a course of action in personal injury, it requires damage, and so the date on which the cause of action accrued is normally the date of damage. And often in personal injury claims, for example, trips and falls, the damage is obvious, so it's sort of not latent, it's more blatant. But in other areas, such as clinical negligence, the damage may not be apparent even to the injured person, and this is where the date of knowledge discoverability test applies. So in terms of what a claimant would know, this is a range of different things potentially. It's what they might reasonably expected to have discovered themselves, what they could have done so with the help of an expert, that being constructive knowledge, whether they can make the associations between the material facts to draw it together to understand that they've got sufficient knowledge to make a claim. They may be aware of a problem but not know who the defendant was who caused it, or they may not be aware, very often, certainly within clinical negligence cases, that the problem even exists. So this is the discoverability test, as it were. This is set out in section 14 of the Limitation Act, and it's pretty helpful because it sort of builds into the Limitation Act a way of providing some guidance or a route through to find out how you would establish what the date of knowledge actually is. So it requires the injury in question to be significant, and I'll be looking at these terms and breaking them down in a moment. But so one is significant, the injury is directly attributable, and also the identity of the defendant. And then there's this final matter about whether the claimant was aware of the association of or the breach or the tort being actionable in law, which is, as you might imagine, irrelevant. So looking at something that would be significant. So this is set out in section 14.2, and it's based on effectively a subjective appreciation, understanding of the facts that the claimant was aware of, but viewed through the objective lens of a hypothetical, reasonable person. So this is a kind of classic legal subjective objective test. But as section 14 goes on, it becomes effectively more objective. And I put in a case there of A and Hall, which is an allegation of historic sexual abuse case, and this confirmed and looked at situations, for example, when a claimant might be in denial of something, and they said that wasn't a reasonable point to take under section 4, but it fell under section 33, the discretion of the court. So in terms of significance, it's whether a hypothetical reasonable person who knew what the claimant knew would have considered the injury to be serious. In terms of what's attributable, again, this is slightly nuanced as well. So it would be whether there was a real possibility that the damage resulted by the action or the inaction of the defendant. It doesn't require, as stated before, attribution in law. So, for example, someone might know that something's gone wrong, but they wouldn't necessarily need to know that the standard of care would be that of a reasonably competent body of surgeons. I give some other examples. For example, an example of a dental case where the claimant began to suffer symptoms following a root canal treatment, for example, whereas it might not be immediately obvious that the cause was the dental surgery itself, or under other circumstances it might be clearly attributable to it. So there's other classic examples of in other areas of law, such as when an employer was responsible for deafness, and it might not be particularly obvious to that person. I'll come on to a case later under these circumstances where that the deafness was necessarily attributable to the employer. And again, they don't have to stand whether it was or was not a breach of duty. There's a case which I haven't put down there, but it's the case of Spargo and North Essex District Health Authority, which considered that attributability would be a situation where a claimant was capable of being, or a circumstance was capable of being attributed to the defendant, in the sense of it being a real possibility, but it doesn't need to go much beyond that. The final issue is whether, which is set out in section 1, is that of identity, and that often doesn't tend to be too much of an issue, so I'm not going to go on to look at that. Looking now at this 14.3, so this is more of this constructive knowledge. So it includes both facts observable and ascertainable by the claimant, and those which would be ascertainable with the assistance of an appropriate expert. So I've got a case here which I just alluded to, which is Johnson and Ministry of Defence. This is a claimant who worked in a dockyard for the Ministry of Defence for a number of years in the 60s and 70s. Sometime much later than that, in somewhere around about 2001, he found himself cupping his ear when he couldn't hear people, and his friends told him he was going deaf. He attributed this to wax, as you might well do, and it didn't occur to him at this point that it was his employers, or that the fact that he'd worked in a very busy dockyard was the cause of it. In 2007, he was actually approached by a claims management company in a car park and went to see an ENT doctor. And it was the claimant's case on knowledge that he only gained this combination of the significance of the injury and the attributability of the injury at this point. Now, looking at the judgment by Dame Janet Smith, she made a number of points, and she used as reference this idea of the reasonable man, who's often used in legal terminology as being an objective, reasonable point of view. And she believed that a reasonable man in the 21st century would have been curious about his onset of a deafness at a relatively early age. And it followed that, she said, I think it probable that if the GP had been consulted as to the cause of the deafness, he probably would have asked the applicant's employment history, and the possibility of noise deafness would have come to light. Dame Janet Smith gave the claimant in this instance 1 year's thinking time. So she said that the expiration time was had expired before he brought the claim, and that had expired already in 2005. So how she looked at that was how, considering what a reasonable person in the claimant's position would have done, what inquiries would they have made. In this instance, it was an inquiry to go to his GP and find out why he was having trouble with his hearing, and then to try and hypothesize on what information those queries would have disclosed. And I think in first, but maybe it's necessary to impute a degree of curiosity. So the test is essentially what knowledge a reasonable person in the claimant's position, knowing what the claimant knew, might have and should have acquired. So the fact that he went to a doctor much later and found out the cause, and he didn't join the dots himself, wouldn't necessarily mean that that his date of knowledge was much later. So looking just broadly at an approach to the date of knowledge, there's certainly a subjective element, what the claimant knows as a fact, and these are set out in section 14.1 from A to D. And then there's this objective element as to what a hypothetical reasonable person would have made of this. That's set out in 14.3a. And what would that reasonable person have done? What inquiries would they have made? What would those inquiries have thrown up? And what would be the conclusions that they got to it from then? Looking at just an example of something that I was sort of thinking about the other day in terms of a case. So in terms of a claimant, whether they had sort of various symptoms in their mouth. So there's many different types of dental negligence claims, but in types of pain, rather than it being an immediate pain, but perhaps a pain that was more of an insidious ongoing nature, it'd be important to find out how these symptoms that she was describing of impacted upon her, to be able to say when the issues would have become significant from her point of view, and then look at what a reasonable person would have done, and whether they, at which stage, have sought a second opinion, and certainly what they would have said from there. So that's looking at latent injuries, and I'll pass you back to Jimmy for running through some of his holiday snaps, I think.
Yes, that is quite right. So Rhodri has dealt now with some of the key questions about when the limitation period will have begun to run, or did begin to run. Now the next two sections are about how long the limitation period is, and there are two subcategories that I would group them into. One is situations where the injury hasn't happened on land, it's happened either on water transport or air transport or in a different jurisdiction on land. And then the second is where the cause of action isn't your typical common law negligence or breach of statutory duty case. So dealing first of all with where the injury occurred, it may be you never in the course of your practice ever have a claimant who has anything other than a road traffic accident on land or slip or trip or whatever else. But if you ever do have a claimant who comes to you who is injured in the course of an aeroplane journey or while they're on water in some way, it's useful to pay attention to the following slides. So the first area is air travel. And for many years, up until probably 2020, there's been an increase in international air travel. And so there have been a couple of attempts to codify the rules of air travel. The first one being the Warsaw Convention, and that's been superseded more recently by the Montreal Convention. And the UK is a signatory to the Montreal Convention, so it applies to any international carriage which starts or ends in the UK. It makes sense to unify those rules because, of course, if you were to get on a plane in London, fly over to Florida, something happens on the flight, for example, maybe a cabin crew member spills a hot drink in your lap, you wouldn't want to have to work out, is this UK law that applies or is it Florida law that applies? You know that it's going to be the Montreal Convention that applies. And I should emphasize at this point that the Montreal Convention is an exclusive jurisdiction. That means that it will oust any other form of claim. You cannot, for example, bring a claim for common law negligence alongside a claim under the Montreal Convention. It's the Montreal Convention that takes precedence over any other form of claim. And I should also emphasize that it doesn't apply just to when you are on the aeroplane itself. It also applies where you are in the process of embarking or disembarking a flight. And of course, that's open to some degree of interpretation. I've cited one case here of Adatia in Air Canada, which very briefly was a case where there's a woman who'd come over from Toronto. She arrived at Heathrow with her elderly parents. Her mother was being pushed in a pushchair along one of those moving walkways that you get. And the moving walkway got stuck, or the wheelchair got stuck at the end of the moving walkway. The claimant got crushed between the wheelchair and the side of the moving walkway. And the court in that case held that that wasn't part of the process of disembarkation, so the Montreal Convention didn't apply. But you can easily foresee if somebody, for example, were to have a trip while they were crossing into the little tunnel between the airport building and the aircraft, that would probably be within the scope of embarkation. The point is, you should be aware that if the accident happens in the course of being in an airport, potentially anywhere from check-in onwards, you may want to consider which law applies. I've set out the relevant limitation provision, which is in Article 35. And what I would highlight, as well as the exclusivity of the Montreal Convention, is that it's a brutal provision in that limitation doesn't just bar the remedy, it extinguishes the right to bring a claim. The general principle in English law is that the limitation is a procedural defence. It has to be raised by the defendant in order for it to take effect. But in cases of the Montreal Convention, after 2 years have elapsed since the date that you would have disembarked the flight, or that you did disembark the flight, that's it. It's gone. You no longer have a right to bring a claim. And what that means significantly is there is no discretion under Section 33 of the Limitation Act to extend the limitation period. But probably more importantly, if you have a child or a protected party who is injured on a flight, they similarly cannot suspend or interrupt the limitation period. So if you have a child who's injured on the flight, don't wait until their 21st birthday to bring the claim, or after their 18th birthday, bring it within 2 years of the date that they disembarked, because otherwise you will be left with an unviable claim. It's probably the harshest of all of the exceptions that we're going to go through. I should also note, because we're in Bristol, that apparently it may apply as well, the Montreal Convention, this is, to hot air balloon flights, not to paragliders, apparently, because there's a distinction between whether or not you're using the aircraft to be transported from one place to another or simply for recreational purposes. And another distinction between paragliders and hot air balloons is that the latter are regulated by the by air traffic, where it will have to have certain licenses in place, whereas you don't if you have a paraglider, apparently. I should note, finally, on the subject of air travel, the Montreal Convention applies indirectly. It's been incorporated into UK law by means of the Carriage by Air Act application of provisions order 2004. So there are identical provisions in relation to limitation if you're taking a flight, say, for example, from Bristol up to Edinburgh. The only exceptions when it comes to air travel that I can find are if you are in a private aircraft, in which case then you just apply usual common law. So that's air travel. The practical point I would raise out of both air travel and any accidents on water is assume that it's a 2-year limitation period unless you can be very satisfied that it's not, because similarly as with the Montreal Convention, the Athens Convention and the Merchant Shipping Acts are not as forgiving as general limitation law. In terms of having an accident on water, the first thing you need to consider is, are you suing, for example, another boat that has crashed into the boat that you are on, in which case you would apply the Merchant Shipping Act, or are you suing the carrier of that you're traveling with? So, for example, you get onto a cruise ship, you have an accident on the cruise ship, it's the cruise ship that you blame. If you're suing the carrier, then typically you're going to be bringing the claim under the Athens Convention, provided that other criteria are established. One interesting point that's raised by accidents on water is, again, what is a boat? I've cited a case here, which is Stedman and Schofield, a 1992 case, which involved a claimant who was riding a jet ski just around Palace Pier off Brighton and had an accident. At that point, the question was whether or not a jet ski is a boat. The definition, or a vessel rather, the definition of vessel for the purposes of the statute that the claim was brought under, the Maritime Conventions Act as it was at the time, is it applies to any boat or ship or other vessel which is used for navigation. And in the Stedman case, the court had a long consideration, quite an interesting consideration about what constitutes a boat. And the court found a jet ski is not a boat. It's not a vessel either. It's not used in navigation, because navigation means moving in a planned or ordered movement from one place to another on water. Now, I raise this because you may have seen in the news reports this week, there was a 28-year-old man who was arrested under COVID regulations because he used a jet ski to travel from Scotland across the Irish Sea to the Isle of Man, a 4.5-hour journey, to see his girlfriend, and he'd never used a jet ski before. So that suggests rather you can use a jet ski to navigate and plan or order your movement from one place to another. I'll leave it to you to decide whether or not this is totally reckless behaviour on his part or a grand romantic gesture. In any event, if he'd had an accident on that jet ski, the law as it stands you wouldn't apply the Athens Convention to it, or the Merchant Shipping Act for that matter. So the Athens Convention is probably more familiar to anybody who's dealt with travel claims because it applies in more scenarios. What I would note about the Athens Convention is that there are some parallels with the Montreal Convention, but there are also quite a few differences. It's Article 16 that sets out the limitation clause. I've highlighted a few points there, but we'll come to those in a moment. The key distinctions, the key similarity is that it's an exclusive regime. If you've got a claim in which the Athens Convention applies, it's very likely that that will oust any other claim that you might bring. So you can't bring your typical claims for common law negligence, or say, for example, you're on a boat or a ship and you're supplied with defective goods. Again, you'd be applying the Athens Convention to your claim. The differences between the Montreal and the Athens Convention are that there is a limited way in which you can suspend or extend the limitation period for minors or for protected parties, people under a disability, which Montreal, as I said before, doesn't allow for. What I would note, though, is beware, because it's only 3 years. There's a long stop of 3 years in which you have to bring your claim. There was a case in the Supreme Court, which I've cited in the slide, of Warner and Scapa Flow charters. Very briefly, that was a case where a Mr. Warner chartered a vessel in August 2012 from the defendants. He was killed in a diving accident, so his wife brought a claim on her own behalf and on behalf of her infant son. The Athens Convention was held to apply. I should note, similarly with the Montreal Convention, the Athens Convention does apply generally to water transport within the UK as well, pending certain other criteria. So in every case, you should always check to see whether it's going to apply or not, because there are a number of criteria there. But the date of disembarkation would have been in August 2012. The action was brought in May 2015. All of the courts all the way through held that the wife's claim was time barred, but the Supreme Court did find that the Scottish equivalent provision to Section 28 in the English and Welsh Limitation Act did fall within the meaning of extension or suspension, which meant that having brought the claim within 3 years, she was entitled to carry on with the claim for her son because she'd done so before the 3-year long stop. But it's quite easy to see if you just left it until after that 3 years, expecting that you can extend it beyond that point, you would run into some difficulty. Finally, in relation to transport claims, I include this slide simply for completeness. I've personally never had a claim involving an international railway journey. I don't propose to deal with this in any detail because it really isn't that applicable to the UK, bearing in mind we only really have the one major international rail route. If you did have a client who came in and said, I was on the Eurostar and a suitcase fell on me, then you would look at this convention, but I won't go any further than that. Now, in relation to accidents that occur abroad, this again is a large subtopic. The general principles I would set out are as follows. When you're looking at accidents abroad, you need to consider both jurisdiction and also applicable law, which are two separate considerations. Jurisdiction being, can the courts in England and Wales hear the case at all? And if they can, then what is the applicable law? And it could be the law of any other country. Potentially, it could be the law of France, or it could be the law of Germany, Australia. Now, the Foreign Limitation Periods Act 1984 sets out a general rule that limitation will be decided by the applicable law to the case. There is an exception, which is if it would conflict with public policy or cause undue hardship. But from the cases which I've cited underneath, at the bottom of the slide there, none of these were cases in which the application of the foreign law was found to have caused undue hardship. I'll just run through a couple of these cases. So Harley and Smith was one in which there were 3 professional divers who were diving off the side of an oil tanker in Saudi Arabia. They brought a claim against their Saudi-based employer, and it was Saudi law that applied, alleging that toxic chemicals had caused damage to their health while they were in the diving, while they were carrying out the diving. The claims would have been issued within the UK limitation period, but it was argued on their behalf that under Sharia law, which is typical law applied in Saudi Arabia, it doesn't recognise the concept of limitation. So they said, well, we're not time barred. Turns out there was a labour law, however, that was found to be applicable that had a 12-month limitation period, and they were outside of that. That was found to apply. So the claimants allege, well, that's undue hardship on our part, that how should we have known that this was a 12-month limitation period? And the Court of Appeal said this: it's not sufficient to cross the threshold by reason only that the period of 12 months is less generous than the period of 3 years allowed under English law. And that's the approach that's been taken subsequently as well in cases like Naraji and Shelbourne. This was a case of a professional footballer who was signed to Sheffield United back in 2005. He suffered a right knee injury. He went over to America to have an anterior cruciate ligament reconstruction, which was carried out in the state of Indiana by the defendant, Dr. Shelbourne. The operation took place in November 2006. Proceedings commenced in October 2009. Indianan law has a limitation period of 2 years, running from the date of the negligent act or omission. There are also some res judicata issues in the case, but those aren't really relevant. The court simply said again, there is no undue hardship imposed by this foreign time limit. And then finally, the case of KXL and Murphy, that was one where claimants claimed damages, personal injury caused as a result of acts of sexual abuse and assaults as children at the hands of the defendants who ran a Roman Catholic missionary society operating in Uganda. Uganda limitation law is similar to UK law in that there's a 3-year limitation period for personal injury actions founded on tort. It also allows infants to bring a claim up to their 21st birthday, as our law does. But the major distinction between the laws is that in Ugandan law, your right is extinguished after that period has expired. And so these unfortunate claimants, who were all several years beyond their 21st birthday, had no claim by the time they issued, because their claims had been extinguished. The important point to remember is that the court will only consider its undue hardship if it would deprive the claimant of a claim in circumstances where he or she didn't have a reasonable opportunity to pursue it timelessly, if acting with reasonable diligence and with knowledge of its potential application, where the claimant is deemed to have knowledge of the application of the relevant foreign limitation period. And perhaps worryingly for claimant litigators, specifically, it was said the wrong advice as to limitation is not accepted as justifying disapplication of foreign limitation law. So beware of foreign claims. I should note in relation to this, possibly one of the main areas you might encounter foreign claims is on when package travel regulations apply. That is an application of UK law rather than an application of foreign law. So you would apply the English limitation period. But I would note there is some discussion as to whether or not the package tour regulations can be ousted by the Athens Convention. So if you're dealing with a package tour that involves cruise ships, you may want to look closely at that. In any event, what I'd recommend in relation to accidents abroad is if you have any doubt, then try to establish as soon as possible what the applicable law is and seek specialist advice. So you don't fall foul of a particularly short limitation period. So the next topic is cause of action, where that differs from common law negligence. What I've set out here is a series of statutes that either are entirely separate from the Limitation Act or that are specific exemptions within it. I've provided as well a table, which I hope is it's not supposed to be legal advice. It is a ready reckoner, essentially, for checking to see what the limitation period is and when it runs from for the various conventions that we've talked about, and also for the statutes I'm about to talk about. Hopefully you'll find this a useful reference tool if you do have a case which involves any of these exceptions. Very briefly, in relation to the Civil Liability Contribution Act, be aware it's a 2-year limitation period that runs from the date that you have judgment or the date of agreement to pay damages. There's a case I haven't, I'm afraid, put the reference down, but RSA Insurance PLC and Assicurazioni Generali SPA is a cautionary tell. That was an insurer who settled a mesothelioma claim, brought a contribution claim against a second insurer, did so more than 2 years after the settlement, and the Court of Appeal held that was a claim for damages within the scope of the 1978 Act, and it was time barred. And there is no, because it's not a personal injury claim, it's a contribution claim, there is no opportunity for the court to exercise its discretion under Section 33. So you're stuck if that's the position you find yourself in. I'll run through the rest relatively quickly because they don't apply, certainly in my experience, hugely often. With claims under the Consumer Protection Act 1987, it's usually just the general principle of 3 years, but there is a long stop of 10 years, which applies from the date on which the product was last supplied. So in theory, probably this might occur as an issue if you were to have a child with a defective toy, for example, a young child, you wouldn't want to wait until their 18th birthday to bring a claim under the Consumer Protection Act, because it may at that point be extinguished. The Protection from Harassment Act, which I mentioned earlier, is a specific exception to Section 11 and the usual personal injury limitation period. If you have a claim where somebody's alleging that a course of harassment has caused them, say, for example, psychiatric injury, you have a 6-year limitation period. You can't apply Section 33 because it's not a Section 11 claim, but the usual principles regarding disability and extensions do apply. And then finally, there's 2 references to the Human Rights Act 1988 and the Criminal Injuries Compensation Authority. Both of those are separate, again, to the Limitation Act. They both do have regimes by which you can extend the limitation period according to the discretion of the court, which applies different considerations to Section 33. But again, I simply make this point: if you have a case which involves those particular provisions or schemes, then be aware it's not going to be the typical 3-year limitation period. Finally, one other statute that hasn't made its way into my table is the Motor Vehicles Compulsory Insurance Regulations 2003. And this is a limitation horror story that should make us all sit up and pay attention. Howe and Motor Insurers Bureau was a case in 2016 in the High Court. It involved a claimant who was driving his lorry through France in March 2007. There was an unidentified vehicle ahead that dropped a wheel that caused an accident with his vehicle. So there was an untraced driver. The Motor Insurers Bureau dealt with this case on behalf of its French equivalent body. There were quantum negotiations for several years. Obviously, liability was admitted. Proceedings weren't issued until December 2014, and it was held that this wasn't a claim for personal injury within Section 38 of the 1980 Act. Limitation had expired, Section 33 wasn't available, and they were out of time. So a perfectly valid foreign claim was dismissed on the basis that it wasn't a personal injury claim because it was brought under that statute. So if you're dealing with foreign drivers, beware. I've just got 2 more slides to take you through before I hand you back briefly to Rhodri to talk about Section 33. I raise these simply because one of the topics that comes up quite frequently for me from defendants is there's a date on the claim form that is later than the expiry of the limitation period, perhaps only by a few days, but it's later. And so the defendant raises the question, are they out of time? The answer to that is settled now by the case of Barnes and St Helens Metropolitan Borough Council. The reference is on the page. Essentially, claim is brought when the claim is taken to the court. It's when the court receives the claim form with a request to issue and with the appropriate fee. So that's the definition. Obviously, it's an action that the claimant takes that's important, not when the court gets around to issuing it. Usually there is evidence one way or the other from the court based on the date stamp as to when it was received, so you can check to see whether or not they really are on the wrong side of the limitation period. But in my experience, more often than not, they are on the right side of it, even if it's only by a couple of days. I just mentioned 2 more cases there, Lewis and Ward Hadaway and Athens Co solicitors. I mentioned those briefly because a few years ago there was quite a lot of excitement about Lewis and Ward Hadaway because it was a case where claims were struck out as an abusive process because there'd been an underpayment of the court fee. But I believe probably that's not going to be a particularly strong argument in future because of Athens Co, which says that even if it's an abusive process to underpay the court fee, nevertheless, that's not a basis necessarily for justifying the strikeout of the claim. So Lewis maybe has less bite than it might have done before that case was decided. And then finally from me, I raise this point about applying to extend time for service of the claim form because it is an area where it's possible to get yourself into quite significant trouble. You'll know, as we've been discussing, there generally is a 3-year limitation period for issuing the claim. You also have a 4-month period typically to serve the claim form. And the courts deem that to be an extension of limitation and one which shouldn't be taken lightly. There's quite a number of cases, and I've listed them to the right-hand side of the slide, where people have made applications to extend time for service and have done so without notice. And you will come a cropper if the court decides that actually on an application by the defendant to set aside the extension of time, that it should never have happened in the first place, and you're left in a situation where you can no longer serve your claim form and you're out of time to issue a new claim. So it's been described by one High Court judge as being a situation where you are dicing with procedural death, which I think probably puts it about as bluntly as you can be. So if you're going to do it, read those cases first and make sure you're familiar with all of the relevant authorities. So on that note, I've come full circle back to my nightmare before Christmas, and I'll pass you back to Rhodri to conclude.
Thank you, Jimmy. Made me think of wistfully of times when it's possible to get injured whilst you're on holiday. I'm just going to just cover a few points here. The first one is just in terms of it's from a claimant's perspective, when it's likely that a limitation defence has been raised or is likely to be raised, and if that requires to be pled, then it's normally necessary or reasonable to do so, both in reference to sections 11 and 14 of the Limitations Act, by setting out the facts of the case. For example, if it's a late cancer diagnosis or an industrial respiratory condition, for example, and then just simply stating that the symptoms weren't significant until X in time, and therefore the claimant relies upon section 14.1, and then plead further, or in the alternative, any of the relevant provisions of section 33, specifically whether it would be equitable in regards to the prejudice to the claimant, the relative prejudice to the claimant and the defendant, and any specifics set out section 33.3. Section 33, it is a net essentially for catching any perceived injustice that might arise from the Limitation Act. It's capable at the court's discretion of disapplying the limitation period under section 11 or 12. There's a broad discretion. I think it's I don't know how often it's used, because I understand it's quite a kind of expensive enterprise, but certainly when there is injustice, it's worth having the court perhaps take a look at the case and undertake this balancing exercise. But it might also be worthwhile mentioning that the Court of Appeal has stated on a number of occasions that in terms of overturning first instance decisions, they would only do so when the decision of the first instance court was outside what they consider to be the ambit of reasonable disagreement. In terms of looking at this, there's a number of different provisions which are set out in section 33.3. They've been described variously as a kind of hodgepodge of various different provisions. And I haven't put this case down, but the Chief Constable of Greater Manchester Police in Carroll, if you're going to consider an application under section 33, that would be a good point to start with. I've just got a couple of Clyn-Neg cases here that I thought were of particular interest. The first one is Ellis and Heart of England NHS Trust. This is the case of a claimant who had a cerebral abscess and was seen by their GP in February 2013. The GP failed to diagnose the abscess, and then this went on to led to the claimant having some residual neurological deficits. The claim was brought against 3 defendants. And there was an extension that was agreed with the GP, but then after the first GP expert report, the GP was taken off the hook because it was decided that there wasn't any reasonable claim against them. But then when it was subsequently reviewed in order to plead the case, it was decided that perhaps they needed to look at this again. And on looking at it again and reviewing it, they decided that the GP, having taken them off the hook, was again back on the hook. The findings of the court essentially were found on the fact that the defendant couldn't really identify any prejudice other than the fact that they thought they were off the hook, and then they were back on it again. Everyone was still in place. Very little time had passed. There was only a 7-month delay, and no documentation was lost. In the second case, and this is my last case here, this is Rayner and Wolfenstans and Medway NHS Trust. This is a case where the claimant had an epidural associated with a birth in 2014. She asserted at the time that she had a firm belief that it's caused some pain and discomfort, but then subsequently went on to develop hydrocephalus. She had a VP shunt inserted and had various neurological symptoms. The experts felt in 2016 that it might have been to do with a dural puncture during the epidural, but then the experts decided they couldn't support the case, and then the claimant went on to find another solicitor and brought the case against the previous solicitor and the original trust, based on the fact that her date of knowledge only ran from a date considerably after the time, based on her date of knowledge. In a rather long judgment, Mr. Justice Wilkie stated that looking at the level of knowledge, that being able to ascertain when the precise event occurred, it goes beyond that required by section 11 and 14 as to when it began, when it effectively began to run, and it gave the discretion was given to the court is unfettered. It's up to do with what is fair and just in all the circumstances, and then specifically looked at some factors, stating that it was on the burden of the claimant to seek an indulgence of the court to apply section 33. It was a fact-specific enterprise, and a factor which is often raised is the cogency of the evidence. So in this case, as opposed to the previous case, a number of years had gone by, and it has to be said that in most circumstances, as it was in this case, the limitation set out in section 11 is normally appropriate. So that's all I have to say about section 33. It's a big topic anyway, but I thought I'd just dip into it with a couple of ClinNeg cases there. So that brings us to a close, I think, Jimmy. We've just gone a little bit over. I hope you all managed to keep interested, and I'll bid you a very Merry Christmas. Hope you all have a good time despite the changing and vacillating circumstances of whether we are or are not allowed to see the families, and whether we have to use our common sense. Oh dear, we'll see how that goes, but Merry Christmas one and all.